Hey everyone, welcome to another episode of Darshan Talks. My name is Darshan Kulkarni. As you know, I'm a FDA regulatory lawyer and I work with a variety of FDA regulated companies. So if you are interested in FDA regulated products like devices, drugs, cannabis potentially, and cosmetics, food, this is the podcast for you. Our guest today is an experienced intellectual property lawyer with an extensive background spanning over 30 years of practice in trademark, patent, trade secret, and copyright law. She provides broad-based and strategic intellectual property counsel to companies of all sizes related to litigation, prosecution, and transactions in a variety of industries, including clothing, accessories, textiles, jewelry, furniture, fragrance, entertainment, consumer electronics, media, food, and beverages. I've actually worked with her. She is also my attorney around intellectual property and is a resource I go to all the time around things like copyright law and trademark law. She is currently partner at Royer, Cooper, Cohen, and Braunfield. I believe it's in Philadelphia, isn't it?
It is, although I'm based in New York. Our headquarters
Although you're
is
based
in
in New York.
Philadelphia. Yeah.
Welcome, everyone. Please help me welcome Donna Tobin. Welcome, Donna.
Hi, thank you. It's a pleasure, Darshan. And I will just add that you are my regulatory guy. So
You're
I
very
do
kind.
appreciate all the things we've had a chance to work on together.
We too. We're going to actually end up talking today around cannabis and talk about trademark issues associated with cannabis and maybe delve around some of the boundaries and the issues that pop up there. So let me start with a basic question. Could you talk about how do you file trademarks in general and how that applies to cannabis?
Sure. So generally in the US, trademark rights are created upon use. So for example, if you sell a product with a brand on it and you sell it to a third party, you're using that trademark on those goods or services. And that begins to create what we call common law trademark rights. The minute you sell something in connection with the brand, you have rights in that mark. Those rights are limited to where you sell your product. So, for example, if you're only selling in New York and New Jersey, those are where your rights would be. If you seek a federal registration and you get past the trademark office examination and you get a federal registration, your rights expand nationwide, even if you've only sold in 2 states. So you have common law rights, but you can expand those rights nationwide with a federal registration if you comply with the trademark rules.
So I already have 2 questions that jumped out from that. My first
We didn't
question,
even get to cannabis. Yeah.
We haven't even gotten to cannabis yet, but you mentioned it kicks in when you have use. But I know that most people register the mark when they're planning to use. So so you haven't actually got actual use. Does that mean that in that period between planning to use and actual use, you don't actually have any rights to it?
No. So many years ago, the trademark office instituted something called an intent to use application. So now, for almost, I think, over 20 years now, trademark brand owners have 2 different choices. They can either file an application before they use a mark, or they can file it when they have use. So if you file before you have it, you beat out anybody that might come after you. You get the benefit of your filing date while you're doing R&D or figuring out what your product's going to be. As soon as you know the name, if you file, then you have a fair amount of time, at least 3 years and usually more, to actually use it. But you're not going to get the registration in your hand until you actually use it and prove use, which means a statement of use with a specimen showing your product bearing the mark. So What you're talking about is an intent to use application, but that's really a placeholder. While you get your ducks in a row, your application is making its way through the trademark office, but nothing will register until you actually prove use.
So do you have to actually file some kind of documentation saying, oh, just so you know, I am now using it?
Yeah. So just very briefly, what happens is you file an application, you usually get a rejection, frankly, for some reason, because they like getting these things off their desk. But you have an opportunity to respond. You have 6 months to respond, actually, although if you respond sooner, your application goes through sooner. And then you respond. Hopefully you get past all the problems that they have with your application. And within 9 months to a year, assuming nothing major, and by major I mean someone else has a registration, or they find your application, your mark is descriptive, or violates the trademark law in some other way. Assuming that doesn't happen, you'll get a registration. You'll get a notice of allowance within a year of filing. And then you have 3 years from that notice of allowance to prove use. So you still have time to do whatever it is that you're doing to get your product to market. All that time, your rights will go back to your filing date once you get the registration. So, so at the end of that time, when you're ready to prove use, you file what's called a statement of use with a specimen, and it has to be a real specimen of real product that are really in interstate commerce.
Now, am I allowed to, let's say you talk about a 4-year time gap, which is great. It sounds really long. But I know, for example, in the drug world, that's not nearly enough time. So is there any way to sort of postpone that?
Well, I mean, you can drag it out by, not responding to the office action for 6 months. And then you'll probably get another one, and you can drag that out again. But that 3-year period is statutory. So no, you can't drag it out. I mean, you could file another application before that period expires, so that there's no gap where you don't have an application and someone can't sneak in. So theoretically,
Okay.
not theoretically, I mean, you could file a new application, abandon the old application, and drag it out. You can't do that in patent. Well, it sounds like a continuation, frankly, but you could do that if you needed more time. But
So that's how that
you do, yeah. But you do have to claim at the beginning when you file an application that you have an intent to use, a bona fide intent to use,
Sure.
and that really is something that is evaluated. And if you do get a registration and you try to sue somebody with it, one of the defenses is you never had an intent to use, or this was a sham, or it was a fraud, or when you filed it, it wasn't true. So if you're dragging it out over a couple of applications, it may seem like you actually didn't have an intent to use when you said you did. So that's a consideration.
So you need to have a legitimate demonstration of an intent to use. So you need a legitimate reason there were delays, that you were still intending, you just couldn't get it across the finish mark. So now tell me how that applies to cannabis. Are there any wrinkles because it's cannabis?
Can you drag it out until it becomes federally legal? Is that what you're saying?
While we're waiting for federal legalization.
Can you drag it out? Cannabis marks in the U.S. Trademark Office are really kind of not that sexy. I mean, they just follow the rules of the trademark law. So the linchpin of a trademark registration, as we've talked about, is use, and it's use in interstate commerce. And because you can't legally sell cannabis products in interstate commerce, by definition, you can't have the use that you need. I mean, it's as simple as that. It's really, it's just trademark law applied to things that can't legally travel in interstate commerce. And so on one hand, the trademark law applies and registration rules apply to cannabis just like everything else. And if it were legalized, then you'd get to the second hurdle, which is all the other things. Is it descriptive? Is somebody using it? Is it misdescriptive? Is it generic? But because you can't even prove the use that you would need yet, those applications aren't going anywhere. They're all kind of stuck or suspended, except that with the passing of the Farm Bill, hemp products are now getting passed. and registered, and we can talk about that.
Which really so I want to first ask the first question, then get into hemp, which I think is interesting by itself. So what I'm hearing you say is that if President Biden, and I'm still getting used to calling him President Biden instead of Vice President Biden, but if President Biden, and I had the same problem with President Trump, that was even odder because he was a reality star. But the point being, either way, President Biden decides that he wants to, or people think that he's going to legalize cannabis, but we don't know when because he's got to get through Congress. And while most people seem to be in favor of it, there are concerns that it may or may not make it through. We don't know the timelines. Does it make sense for a cannabis entrepreneur to file a mark, knowing fully well that he has a quote unquote intent to use, but and it'll probably happen during this 4-year presidential term, and then just sort of wait it out?
Look, I mean, trademarks are often the subject of hedging and great ideas and that legal term finagling, right? So, every time President Trump said something, it became a trademark application, COFEFI and all sorts of other things. So yeah, I mean, you could try to finagle filing an application for one thing, hoping it doesn't get rejected and waiting. But again, the problem is if you filed for cannabis products at the moment, you don't have a bona fide intent to use in interstate commerce because you can't. So I would say, and obviously, these haven't been decided yet. I don't know exactly what's going to happen. But at the time you signed, the argument, I think, would be you couldn't have had a bona fide intent to use in commerce because it's illegal. And it may never become legal.
But here's the question, and this is the clarification of the language. And I don't know if you know this off the top of your head, but does it have to be in interstate commerce? And what I mean by that is technically they do have the intent to use in commerce. It'll just be intrastate commerce. Does that change anything?
It has to be in interstate commerce.
It has to be interstate. Got it. Okay. So for those of you who are in cannabis and are trying to go down this path, you have to consider alternative strategies. So what are some alternative to me, here's an alternative strategy I would consider as a non-trademark attorney. And then I'd come to you going, Donna, why was this a bad idea? But essentially the question being, can I go, you know what? I'll start with hemp. And I'll start with using it for non-medicinal or recreational uses, and use it for like industrial hemp, if you will. And then making that argument saying, that's what my claims cover. And if you, a third party, want to come into that claim and risk it, we can try our luck in state law, and we'll figure that out then. What is your advice to someone who wants to play Wild Wild West like I just suggested?
Well, okay. First, I think we need to unpack that question.
Okay.
So let's just go back to the beginning of that for a minute. At the moment, for the listeners who aren't quite aware or need some clarification, when the Farm Bill was passed, hemp products became legal, and hence they were subject to trademark registration. And in fact, a lot of hemp products now are the subject of trademark registrations. And I'll just mention that if you have a hemp product and you're filing an application, it would be a very good idea to put the required language in the application right up front, which is that it contains less than 0.03% of CBD by dry weight, right? So there is magical language that you need to get them to know that it's hemp and not marijuana. So that's the first thing. If you don't put that in and you have a pot leaf in your design or your goods sound like they might be marijuana, you're going to get stuck behind a very long line of applications. So the magic language is and I'll share this, it is not more than 0.3% of THC on a dry weight basis. If you put that in there, and you can look it up in the trademark office, there's lots of applications that have issued because now those are not part of the Controlled Substances Act. They were removed by the Farm Bill. So those are perfectly legal now. And there's lots of applications and registrations for those. But back to your question, let's say you are trying to register for cannabis that doesn't fall under the definition of hemp, right? So those are still illegal products. You can register in the states where you're selling and where it's legal, and people are doing that. I think state registers are seeing a lot of activity. Usually, you know, often people did not bother with state registrations, but now it's become important. Investors look for them. State registrations are you know, often attached to business agreements, funding agreements, because that's what you have. And your question, Darshan, was, can you register for other things? I mean, yeah, so it can be two ways, right? So if you are a cookie manufacturer and you have registrations for cookies, and then you want to move into selling cannabis cookies, you can take the position once it's legal that your registrations cover all kinds of cookies, including cannabis cookies. And that's a fair argument. I mean, a cookie to some degree is a cookie. And so if you have other products that you are selling, you can register them and then try to take the position that, you know, these can be expanded to cover cannabis products when it's legal. But again, you have to be selling them. So for example, if you want to sell tobacco, lots of people try to register for tobacco. And if you make that statement that it's not cannabis, it's tobacco, you have to be selling tobacco in connection with whatever brand it is. And then later, if marijuana becomes legal, you can take the argument that tobacco and cannabis are related. And of course, my registration would cover this, and it's a likely expansion, you know, while you also go out and file another application the day after it becomes legal. But those are some strategies. You know, again, you can think about what other products you can file for that are close to cannabis, but you have to be using the brand on those goods. So that's, you know, you need to give some thought to that. And they really do require at certain points in examination, or when you're enforcing a mark against another person, you're going to have to come forward with business plans or proof that you really had a bona fide intent to use. It has gotten to be much more stringent than it used to be.
So that really, it's funny you talk about cookies, because one of the people in the news was Martha Stewart, who has, I think she's getting into cannabis. And I'm literally visualizing her selling cannabis cookie. And I have no idea if she has plans to sell cannabis cookies or not. And if she's one of your clients, don't tell me about it. But the point being, so she's in a better spot, is what I'm hearing you say, to say that any kind of cookies with the Martha Stewart brand or the Snoop Dogg brand will automatically have some level of protection because they're already covered by the cookies trademarks already in place. But she should consider augmenting that with state registrations.
Yes. I mean, on the state registration side, there's no reason why she shouldn't say cookies containing cannabis. She should say that, right? Because she can in the states where it's legal. I mean, you know, let's say she has this cookie registration, and she certainly, if she's selling cookies with hemp, should go for a registration that says cookies containing not more than 3% dry weight of THC. She should file those, which expands that argument that, of course, you know, cannabis is the next step. And of course, my cookie registration covers cannabis because, look, it already covers hemp, right? But what's unknown is whether, the trademark office or courts are going to look at any registration and say, well, of course, this also, iced tea. Of course, it's obvious that anyone would have expanded their iced tea brand into cannabis iced tea. I'm not sure that's true. So, those people with brands have a federal registration for a brand. That's a great thing, but they still should think of what else they can do if they are really thinking of, using it for hemp and cannabis related products.
So here's a weird question for you, because you just raised it. And I want to be clear, I'm not a music aficionado. But Ice-T is a rapper. And if Ice-T is a rapper and you go in with Ice-T cannabis, can he complain saying, no, you are, I'm trying to remember the Victor's Little Secret versus Victoria's Secret lawsuit and the implications. Does Ice-T get a claim going, you are disparaging me with this, with your brand?
So interestingly, you've touched upon one of the only parts of the trademark law that's actually still standing. This is probably for another podcast, but there was a trademark law against registering disparaging marks, against, for example, there was a registration for the Slants or the Redskins marks. Those are not disparaging anymore. The Supreme Court has decided that the trademark office can't make the decision of what's disparaging or not. They have to register all that. So there's no disparagement exception anymore in the trademark law. There's actually also no exception anymore for scandalous marks. So if you ever have some extra time on your hands, perusing what's been registered since that got stricken is fascinating. And I'll just say that the case that started that was a case where a guy tried to register the what he claimed was the abbreviation of friends you can't trust, and that got registered. So, so back to your question, which is association with a living person. Yeah. That is still standing. So you can't register a mark that is the name of or associates or assumes a connection with a living person. So that is why there is a whole highway of littered with rejected applications that have the word Trump in them. Although
I was going to ask that question next. So you can't do Trump cannabis?
No, a few got through because Trump is actually a word and no one can remove that from the English language. So a few of them have gotten through, but yeah, you can't assume a false association with a known person. So if you tried to register iced tea for iced tea that contains cannabis, you would most likely get a rejection that it assumed a false association with a living person, or a requirement alternatively that person approves your use. So you wouldn't get very far with that unless you were friends with Ice-T or you had some business relationship with him.
Now, could I do a stylized version of the trademark so that it looks nothing like Ice-T? So I'm really describing it more as an image than as the person. So let's make it an ultra feminine font with pinks in there, which we know is diametrically opposite from the image Ice-T uses, and then say cannabis next to it.
You can make that argument. The test really is this a false association? Are people going to think of, you're thinking like a trademark lawyer. Are people going to think of Ice-T when they see this? Maybe not. That would be your argument, right? It's not a false association. And if you're actually selling Ice-T, then there's your argument.
Right.
We're talking about our product, but then you'll get a descriptiveness refusal because it'll be the descriptive of your product.
Therein lies the second problem. So if you're now talking about state registrations, what is the process to get a state registration?
It depends on the state. But honestly, most states don't do much of a substantive review, whereas the trademark office actually is a trademark law and has to answer to that and has a bunch of regulations that implement that law. And rejections and refusals are ultimately appealable to the U.S. District Courts and the Court of Appeals for the Federal Circuit. The states can do whatever they want, essentially. And so, it ranges from sending in an application, telling what you're doing, showing a picture of your mark, and getting a registration in the mail, to maybe them checking to see if anyone else filed a registration for the same thing. But they're not extensively, as a rule, they're not extensively reviewed. But again, you only have rights in that one state, and you can't use them to go after someone else, even in a neighboring state.
Is there an issue with conflicts of law principles in the sense that, let's say there's a federal mark and a state mark? If there's a conflict, does federal have an automatic presumption?
That's a great question. So there are very complicated things called concurrent use proceedings. I don't know, maybe this dates me, but if anybody remembers that you couldn't buy Freihofer chocolate chip cookies in New York State, it was because of quirky trademark agreements between different entities. So if someone has a federal registration, but it turns out that somebody else had a registration before them in a state, the federal registration, after a proceeding, can carve out that state if the state user was first.
Wow.
So you'll see some strange registrations that say things like, except for the state of New Jersey.
Okay.
But again, it's based on priority of use. So if the user was in New Jersey earlier than the federal user, that could happen if the New Jersey user decided to do something about it and instituted a proceeding. I mean, when you file your application federally, you have to swear that no one else is using it anywhere in the country. So if you knew about New Jersey, you wouldn't do that unless you got some agreement with them or something. Yeah.
Right. But you wouldn't also actively check. Or, well, you might actively check and find out, and then you have a problem.
Yeah, I mean, honestly, I always recommend a full search be done because you want to know sooner rather than later if you're putting a lot of money into a brand who's going to come out of the woodwork and cause you, heartburn, like the guy in New Jersey.
So Donna, we can keep going with this, and obviously it can take forever. As you know, we try to keep it shorter than where we are as we speak, but that's because you're really interesting. But we're going to ask. We've added a new segment to the streaming and to the podcast. So, would you be open to doing 10 questions as part of a rapid fire round?
Sure.
Okay. What is an accomplishment you're most proud of?
I was until recently selected to be one of 9 members on the U.S. Trademark Office Advisory Board, which when the commissioner called to ask me if I wanted to join, I thought it was a joke or someone with her same name. So I'm very proud of that. It was really an amazing experience to get to meet with the trademark office twice every quarter and be there. I still have my office ID, although I guess it's probably doesn't work anymore. But I was actually really proud of that. That was a really fun thing.
You should be. That was awesome. Who is your hero or heroine and why?
Oh my goodness. My grandmother. That's probably an answer a lot of people say.
No, it's a great answer. Why? What about your grandmom really spoke to you?
She was an immigrant. She was a card-carrying communist.
She really? That's awesome.
Before it became illegal. And she, when I was 5, told me that I should make my own money and be a doctor or a lawyer. But she only said it in Yiddish, so my father had to explain. But she was thinking ahead.
Well, What does she? How do you think she'd react to you defending corporations now as a
I think she would.
communist?
I don't know. She likes food, so she would like the part where I help lots of food companies to make their way through the branding, and I think she would get into that.
There you go. What's your favorite way to give back to the community?
Interesting. So I do a lot of pro bono trademark work. You know, it's interesting when you're a young associate, and there's pro bono requirements in some firms, or at least it's strongly, you know, suggested that you do pro bono. Nobody that's coming for pro bono work typically is looking to register a trademark. You know, they're trying to stay out of prison, or they need help with getting hot water in their apartment, or they've been evicted, and so. Over the years, I have sought out, you know, people who are seeking advice for nonprofits, or, you know, very small startups, people who need help and don't have the funds. So I've been doing that. And as a result of that, I wound up being on the board for 20 years of a nonprofit that I first met by registering their trademarks. And they help survivors of sex trafficking. So, and they have registered trademarks.
Wow, that's really cool.
So, yeah.
How do you define success?
Oh my gosh, Darshan.
These are supposed to be easy questions.
Yeah, they're going to be so, I don't know. Waking up every day and loving what you do.
I love it.
That I just love what I do. And if you can do that and have fun every day, I mean, what's it in my mind, enjoying and having fun is really, you know, what we're here for, helping other people, and that can give you joy as well. But just waking up every day, no matter what you're doing, you know, if I'm hearing a Zoom from Cambodia where some of these nonprofits training centers are, and these women are wearing the sweatshirt with the trademark that I got for them.
Really?
That's fun.
That's awesome.
That's cool. And yeah, and being in court and arguing about cheese labels, that's fun.
What challenges you?
Working from home.
Really? Okay. What is your favorite movie?
Oh gosh. So you don't know this about me yet, but I'm not really a movie person. So my favorite movie is going to show you that I'm not really a movie person.
That's okay.
I don't
we'll
really
try
watch
it anyway.
movies. In fact, as my husband's present every year, I agree to watch a movie in the daytime because I just cannot watch a movie, and especially in the day, it makes me crazy. It's a Wonderful Life. That's my favorite.
That's a great movie. I think that's great. But I love that we learned that
it was made like 40 years ago.
No, it's funny. I'm a huge movie buff, so I love asking the question. And you're the second person I've met who absolutely hates movies. So takes all kinds. What is the most fun you've had recently?
What is the fun? Snowshoeing and riding my Vespa.
Okay.
Not at the same time.
Okay, fair enough.
Not at the same time.
If you were a superhero, what would your power be?
Oh my goodness. Flying. Because I live in New York City and it's very frustrating to get around. Flying would come in handy.
Your big issue is traffic. Of all the powers in the world, you chose getting away from traffic.
Flying could take, I mean, yeah, it could be a long haul flight.
So in your opinion, what I'm hearing is being president is the closest thing to being a superhero because he or she gets to go past traffic without being stopped.
And can register their own name. Well.
Exactly. Oh, that's right. Which really raises the question of whether you can protect the Trump marks.
That's true. Yeah. Yeah. I mean, we could have another podcast on that. But there are some that are registered that use the word Trump as a word, as opposed to as an affiliation. So people can look it up if they want to go to uspto.gov and put in Trump and see what happens, and you'll see what's registered. Things that use Trumps as a verb have been registered because it's not his name.
But at this point, can you actually register because he was a public person and therefore he does not have rights to his name?
He does have rights to his name. I mean, I can't register your name, your full name, if you're identifiable, because unless I have your approval.
I guess let me rephrase the question. Do the family of Abraham Lincoln have rights to his name?
So that's an interesting question. The analysis is this going to be assumed to be an affiliation with a living person or entity? So if there's a Lincoln Project, for example, maybe the examiner would take the position that they have rights in Lincoln. I mean, Abraham Lincoln himself doesn't, and his family doesn't anymore, unless there's some entity that's using that name, and there'd be a danger of an affiliation assumption. That's really so that's why Trump still has his rights.
Okay. Right. If you won $1 million, what would you buy? Means less in New York, but still.
This is more than 10 questions, I'm thinking.
No, actually, we're at number 9.
A parking spot? No.
I knew New York prices were high. Did not realize they were that high.
I would buy a house in a remote location. I really love remote locations. I've been to the Faroe Islands. My next trip is Greenland, hopefully. So I would buy some thing there, and then the vehicles to get there.
I love it. There's a Where Did You Go, Bernadette? Have you read that book or seen the movie?
Which?
I think it's called Where Did You Go, Bernadette?
Oh.
I'll have to. Oh, it's a movie. So
I've
now.
heard of the movie, but I didn't. Yeah.
There's a book too.
I've heard of it.
Okay, fair enough.
Books I do, but I haven't.
I have 2 remaining questions. I'm going to ask you only one because I know this has been more painful for you than you're polite to admit.
I'm fine.
If you were going to build a Mount Rushmore to 2020, who would be the first person on it and why?
I'm sure that other people have said Dr. Fauci, but that's my entry, Dr. Fauci.
Actually, you're the first person to say Dr. Fauci.
Because he has a really identifiable face, and because we needed a voice of reason, and I think he was that. No matter who you are, I think that hearing him was comforting, and because of him, I didn't have a Thanksgiving gathering. So.
Is that a good thing?
Or Christmas or Hanukkah or anything else. I'm still here. I'm still good.
Okay.
I still haven't ventured far from my house. Yeah.
So let me recap today's talk. We spoke a little bit about cannabis. We spoke about the process to get a trademark. We started off by discussing what it's like for a regular trademark and then got into cannabis-specific issues. We talked about things like state registrations. We talked about the difference between intent to use and actual use. We talked about limited rights on use. We talked about state registrations and Martha Stewart for some reason and iced-tea. Is there anything big I missed?
No. I mean, again, it's interesting because there's so many considerations when you're planning a cannabis brand, right? Or you're, starting a business. Only one small part is the trademark aspects, and sometimes it seems like they are like in a parallel universe, regulation, what you can sell, what you can't sell, where you can sell it, all of those things are separate from the branding, which is a really important part of that puzzle, right?
Yeah.
So sometimes it's shoved off to the side, or it's kind of, we'll get to it later. And, it should be up there with some of the main considerations. and planning ahead, knowing the minefields and what you've got to work with now, which is you can't register it federally, but you could do other things, could put you in position to take advantage later of a more robust brand.
Which is why I think it's important to recognize that nothing in this podcast should be construed as legal or clinical advice of any kind, and it's intended for educational and entertainment purposes only. For those of you who missed it, Donna, where can they reach you?
By email is great. dtobin, Tobin, at RCC, like Charlie, B as in boy, law, like law, rccblaw.com.
Okay. And if you like this podcast, please leave a comment, please subscribe, and you can find me at Darshan Talks on Twitter, or you can go to our website at Darshan Talks. Thanks for joining us again, Donna. Love to have you on again.
Thank you. This was fun. Thank you.